All right, everybody. Thank you so much for being here. On behalf of Trident Training, Trident Title, and Performance Title and Escrow, I want to welcome our special guest, real estate attorney extraordinaire, Paul Krasker. We have over 80 people on this chat here for you. I have a line of questions to ask you in our Ask the Attorney series. And Paul, I would like it, if you don't mind, if you give us a minute or two about you, some of your experience, some of your background, and then I know you have some contract stuff prepped, and then we will dive into the questions. So take it away, Mr. Krasker.
Sure. Can everybody hear me okay? Thumbs up, thumbs down?
Yes, sir.
Good. Thank you. I've been practicing real estate law in Palm Beach County for 30 years now. I've been affiliated with Trident Title and Performance Title. I was one of the co-founders with John Weber of Trident. And I've spent the last 3 weeks or so talking to most of the real estate attorneys in Palm Beach County, trying to grow consensus on where we stand and what everybody thinks is going on and how everybody should react to it based on the contracts. Not sure what any other relevant history or anything else, but happy to get into the talk if you're ready to go.
Yeah, that's perfect. So thank you for that, Paul. And I know you had some contract stuff you wanted to talk about before we dive into questions. So share that with us, your wisdom, your knowledge on what's going on.
Okay, thank you. Yes, everybody's asking the same few questions. Unfortunately, the Spanish flu pandemic of 1918 didn't leave us with any appellate case law in Palm Beach County on how to handle a pandemic like this. So most people are required to look at the FAR bar contract. Sorry about that. I think this is the contract that everybody's been working off of, which is the FAR bar contracts. The most relevant positions or paragraphs of the contract are 15A and 18G. And I'll just go through paragraph 15A so that everybody understands that if a buyer is in default under a contract, what the remedies are. Because I'm getting a lot of questions from buyers of, what are my options? In my contract classes, I always teach that in paragraph 15A on lines 329 and 330, you should cross out the language that says, or seller at seller's option may, pursuant to paragraph 16, proceed in equity to enforce seller's rights under this contract. If you are somebody who's followed that religiously and that's crossed out of the contract, then if the buyer is in default, the only remedy available to the seller is keeping the deposit money, period. If you're not crossing that out religiously, and in fact you've got contracts that don't have that language crossed out, then the seller has two options right now. The first option the seller has is to keep your deposit, terminate the contract, and everybody walks away. The second option is for the seller to not retain the deposit immediately, but keep it in escrow and sue in equity to enforce their rights under the contract. What does that specifically mean? That means that the seller can go resell the property to somebody else. And let's say it was an $800,000 purchase price, but that somebody else who comes along is only willing to offer $700,000, then the seller would be able to sue the buyer for $100,000 plus any carrying costs from the original closing date to the second closing date. So that is a risk, and you need to be able to tell your buyers that that is a risk if they decide to walk away during this process. The way to mitigate that risk and to eliminate the risk altogether, if you can, is if the buyer's willing to walk away from their deposit, is to get that release and cancellation form signed that says both parties and the realtors have no claims against each other after the full execution of that document and the disbursement of the deposit to seller. If you don't get that signed, you always run the risk of somebody coming back at a later time. So remember that form. If, there's one other point in paragraph 15A. If the sellers decide to retain the deposit, if the seller decides to retain the deposit and the buyer agrees with that, keep in mind, if you're representing the buyer in the transaction and the seller has an obligation to give the listing agent 50% of the deposit money, the line in 331 says that the cooperating broker, the buyer's agent, gets to share in any commission that the listing agent receives. Many times the listing agent just waives the money once they know that they're only getting 25%, in hopes of keeping the listing or extending the listing time period. But be mindful of that issue so that you can decide what to do. The other paragraph that I just wanted to cover with everybody is the one that everybody's calling me on, which is paragraph 18G. 18G is the force majeure paragraph. I've had a number of people ask me my opinion on whether force majeure is applicable here. And my opinion, and the opinion of most of the top real estate attorneys in the county, is that it is applicable here. There are state, federal, and local guidelines that have all said that you should be practicing social distancing, that you should not be putting yourself in a position where you can catch this virus, to require a buyer to do a pre-closing walkthrough prior to closing in an environment that they don't know who's been in, and requires that they become out there in the public to potentially catch something, is something that I believe a court will determine to be force majeure, an act of God. And the contract specifically states that anybody who can't perform has until 7 days after these restrictions are lifted to perform. And it goes on to say that if these restrictions stay in place for more than 30 days, either party has the right to cancel the contract. So it becomes a waiting game for everybody involved. And one of the things that you can use to your advantage when trying to draft language to address the issues at hand are to say to a seller, look, you have a risk here that if this goes on for more than 30 days, the buyers can terminate, walk away, and get their deposit back. And by the same token, you could say to the buyers, look, I know you want your money back, but you don't have a right to do that until 30 days go by. And if the health department for the county or the state or somebody else turns around and says, we're through the worst of this and we're lifting the restrictions before the 30-day period expires, then you're going to have to be held to the contract and you're going to have to close. So if people are trying to work out something between them, you can use those techniques on both sides to come to a middle ground. The middle grounds that I've heard from creative agents and other attorneys are to negotiate an addendum that gives plenty of time. If you're worried that this is going to go 30 days and you're a seller and you want to give somebody a 60-day closing extension today, that means that if the force majeure were still in effect in 60 days, they could use the force majeure paragraph again to delay for another 30 days, but at least you've gone past the time period that everybody thinks will be in this sort of stay-at-home request mode. Other things that I've heard creative people do is offer to lease the property for a year or for six months and a day, so that the buyer doesn't lose their deposit. The buyers can take a thoughtful pause and see what really happened in the stock market and in the business world to determine if it is something that they want to go forward with or not, so that they don't have to lose their deposit up front and have the ability to have a thoughtful response and a thoughtful decision. And others have just agreed to disagree about whether or not they have a right to cancel and negotiated a split of the deposit, or a maybe not evenly split or whatever, but that's another avenue that people have gone down.
That was awesome, Paul. I feel like you answered probably 20 of our 25 questions just in those two things. So guys, remember, if you're on this call through Performance Title and Escrow and Trident Title, you get the access to his brain. So make sure that you are working with your reps and working with our people to connect so that you get access to Paul. Anything else you want to add before we dive into the questions?
No, let's go ahead and take them.
All right. Is it possible to have an entire closing while sheltering in place? And if so, how does that work with the notary?
So the good news is that Fidelity National Title, which is a parent company of Trident and Performance, has approved online notarization. It's only approved for limited circumstance. The statute limits it to U.S. citizens only. So if it's a Canadian, can't do it. If the property is held in a trust, that may be problematic as well. You're not allowed to have a power of attorney used with a trust, so it has to be the original trustees. If there's multiple parties, it may be more difficult, but can be done. The one other limitation that I'd state is that most lenders have not approved remote online notaries called RONs to do loan packages yet. So, if you're getting a loan from Wells Fargo, Bank of America, Chase, Citi, all the big 6 or so, that's not an option for you right now.
Got you. Okay, great. Thank you.
Can I add to that, Ryan and Paul? It's Gabrielle.
Yes.
Just kind of for some added peace of mind, because first of all, guys, keep in mind that remote online notaries, it's not simple like it sounds. The clients have to be tech savvy. There's a lot of tech involved. I believe, Paul, you can correct me if I'm wrong, I believe I heard they cannot sign the deed via a remote online notary. So, they're still going to have to, get the deed wet signed and notarized and witnessed. However, I did want to share that we had a mobile closing recently. The people were elderly. They did not want the mobile notary in their house. And we were approved. The notaries were fine with it, and Fidelity was fine with it. They actually sat outside through a window. The people held up their IDs so the notary could see it, and they passed the papers back and forth and did not have to enter these people's houses, and they were still able to get everything signed. So, we are able to do things like that to make this work. So I just wanted to share that with you guys.
That's awesome. Thanks, Gab. Yeah, Performance and Trident both together have really gotten on the forefront of this with everything possible that we can do to get these things closed. We're getting them closed. We're still bringing in orders, and we're still closing orders. So awesome. Good stuff, Gab. Paul, next, what addendums, if any, do they need to use? So do people need to use that COVID-19 addendum, or is that just still an option?
It's an option. It's not required for use. Depending on your goals in the transaction, you have the right to use it, as you have a right to use any addendum that's out there.
Awesome. Thank you. Can a buyer renegotiate a contract price because they lost money in the stock market with proof of funds to show before and after?
Yeah, I'm going to say no to that. I'm going to say that's not force majeure. And you get people who argue that to you, and I think the easiest way to answer their question for them is to say, if your portfolio went up at any time, can I charge you a higher purchase price?
Okay, this one's not COVID-19, but my seller gave her daughter the power of attorney in the sale of the house. There is another owner who is deceased, yet his name is still on the property taxes. They do not have a death certificate. How do we go about getting a death certificate, and how do I include the daughter with power of attorney on the contract?
So the interesting thing is that the underwriters at Fidelity National send out these Title Tuesday notes to everybody to keep everybody sharp on their toes. And I always read them. And this was the one that was sent over about 3 weeks ago. So whoever's doing this, they're right on target.
Yeah, I think this is the Borriello, Melissa and Vinny Borriellos.
Great. How do you go about getting a death certificate? The funeral homes hand them out. So if you go to the family and ask who the funeral director was, call them up, they'll have them. A couple of tips regarding the death certificates. If it's a Florida death certificate, there are two types: the long form, which has a cause of death, and the short form, which does not have a cause of death. We need the short form. There are a couple of tricks to this question. So the first trick is you need to make sure that the two people who were on title together were on title as joint tenants with rights of survivorship, or as husband and wife, or as tenants by the entirety. All three of those mean survivorship. And as long as there was survivorship, we can record a continuous marriage affidavit or a death certificate, and the survivor amongst them can properly transfer the real property to a third party. If it was not held as rights of survivorship, if it just stated the two names, it is deemed to be tenants in common. If that's the case, you need to know as soon as possible, because if it's tenants in common, you actually have to open up a probate for that other person who's deceased and probate that asset and appoint a personal representative to be able to transfer the asset. So check the deed as quickly as you can to make sure you're okay.
Great.
Obviously, if you need us to probate that, we can get it done as quickly as we can, given the fact that both probate judges were out this week so far. And then the last question had to do with the POA. If the property were held in a trust, again, you cannot use a POA with a trust. So that would be very different. But assuming this was held with two people individually and one person's left remaining, if they have a proper power of attorney executed in behalf of, in this case, I think the daughter, then the daughter can sign. How you want to sign a listing agreement, how you want to sign a contract, you want to put on the top of page 1, the mother's name if she's the one who's surviving, or the father's name. And then on page 12, where the signature is, you want the daughter to sign the mother's name and then put a comma and then say by, and then sign her name and then put another comma and say attorney in fact. That's the proper way for somebody to use a POA. So again, you'd sign mom's name, comma, daughter's name, comma, attorney in fact.
Got it. Great. Thank you. If there is an escrow dispute due to a canceled contract, when can the seller show and take another offer?
Is that happening today? Just
apparently.
Yeah. So we have to be very careful here. We need the buyer to send a written note of cancellation. Needs to be in writing, can't just be on the telephone. If the buyer cancels the contract and says, I am not going forward with this deal, period, I hereby terminate, or I consider the contract void, you can take that would be deemed a cancellation, and we can give notice to both parties. If we're the escrow agent, Trident or Performance can give notice to both parties that they have a certain number of days to resolve the escrow dispute, after which we're going to interplead the funds. And my office can interplead the funds and put it into the court and say seller and buyer have a dispute as to who's entitled to these funds, and good luck to both of them. And then we can go ahead and sell the property to a third party.
Got it. Do you recommend adding verbiage to the contract or an addendum that would automatically extend the closing X amount of days if there is a delay caused to COVID-19?
So it's always good if you're signing new contracts to have language in there that acknowledges that there may be requirements to not be outside, or there are existing limitations on transportation and interactivity with others, and put something in there that says that it can be delayed at either party's request for up to 30 days.
Okay.
It's already in a contract in paragraph 18G, but this way everybody would be acknowledging it up front, and you wouldn't get somebody who's pig-headed and says, oh, there's no problem, you can close this tomorrow.
That answers a couple also, because a couple people were asking how long should they extend, or what's the timeline allowed for extension. So that would be 30 days. Is that correct?
Well, the timeline in the contract that allows for cancellation is 30 days. So if this extends beyond 30 days, either party can cancel. If you want to try to keep your deals together, the longer the extension you can get for people, the better it is for everybody.
Okay. When is the most appropriate time to use the addendum? You already stated that, right? As early as possible on new contracts,
Yes.
if possible.
Yes.
The buyer backs out. It is our listing, and there was an escrow dispute. Can our agent put the home back on the market and resell?
Yes.
You address that one. Is there a way to get a digital closing when seller is not an American citizen and is not in a country that recognizes American citizens? They said Venezuela is the example.
Yeah. I'm not aware of the Florida remote online notary statute requires that it be an American citizen. So I don't believe that Fidelity is making any exceptions to that. And I've got somebody stuck in the Bahamas right now who've signed all their papers and can't even get a plane to fly it back over. So it's quite frustrating, but that's a delay, period.
For sure. If one party requests to use force majeure, must it be required or accepted by the other party? So do they have to say yes? Is this a forced thing, or?
Yeah, so force majeure is a concept. It's not something that people get to dispute, and that'll be decided by a judge. Most real estate attorneys that I've spoken with believe that force majeure is in place right now because of the travel restrictions, because
Wow.
of the
So
threat
what does
of
that
containment.
mean? That's my question.
Oh,
Oh,
let me mute.
I'm not muted.
All right. Back in there. Is it true that a deed cannot be signed using the RON?
I don't know the answer to that question.
Okay. If a buyer has been advised of a reduction in salary 3 days before closing, after mortgage approval has been received, is there any way for them to get out of the contract?
Yeah, I had a buyer who was terminated 3 days ago, 2 days before closing. That's the risk that buyers take in contracts. Once they're already through the loan approval period, it's their risk that they're going to remain employed through the closing date.
Great. Would you recommend the lease with purchase option contract? If so, just use the standard form, or do you want them sending that to your office to write something up with these crazy times? How would you want that handled?
Say the first part of that again.
Would you recommend using a lease with a purchase option? And if so, is that something that they should use a standard form for, or use you?
I would not encourage any agent to draft a purchase option. I think it's a risk. There are a whole bunch of issues that need to be addressed as part of the purchase option. Notice periods. There's got to be consideration for the purchase that's separate from the lease. So they're complicated paragraphs, and we probably should draft that lease option for them. I think we charge a fee to draft a lease purchase option. I don't think it's significant. I think it's $550. And it's probably worth the seller's the seller's time and effort to make sure it's an enforceable contract.
For sure. What happens when buyer has contract past the mortgage commitment date, buyer has mortgage commitment and loses job? You just touched on that one. How do you suggest I handle a walkthrough in the upcoming days, Wednesday, Thursday, Friday? Should we go? Should we not go? If closing is scheduled for Friday, what are your thoughts?
Yeah, I mean, that's the most difficult question that everybody's asking is, you know, do you have to be there? No, you don't have to be there. Is it a risk? Yeah, it's a risk to be around people and not to be social distancing today. You know, I was reading this morning that they just came up with the analysis for that Princess
The cruise ship, right?
cruise ship,
Yeah.
and they say that there's the germs were staying on surfaces for 17 days that they were living. So, you know, if you're an agent, you're going to the house and you're touching appliances and doorknobs and everything else, and somebody's infected, then you've got a good chance of being infected.
For sure. I have a
Can you
client.
take precautions with gloves and masks and all the rest? Probably.
Got it.
So-
I have a client who's in the middle of a divorce right now, wants to buy a property. If she purchases before the divorce is finalized, will the ex-husband need to sign off before she resells?
The ex-husband will need to sign the mortgage, the truth in lending, and a couple of other loan documents. The ex-husband would not have to sign the promissory note and would not have to be on the deed. But yes, the ex-husband would be required to handle that.
Okay, and a couple more non-necessarily COVID-19, but then we're going to cut this off. 5 or 6 more here. What if a client is declined just after mortgage contingency date? Can they still get their deposit back? Really, you talked about that. The buyer goes to arbitration. Does that keep the seller from being able to relist the home if they are actively in arbitration?
So the contract says that if there's a dispute about the deposit, there's a 10-day pause while they try to work it out themselves, after which you go to mediation first. If it's not resolved at mediation, then depending on what the parties agree to, they can either go to arbitration, or if they don't mutually agree to go to arbitration, they can go to litigation. If we're involved and we're holding the deposit, we're going to give them a limited time period to resolve it themselves, after which we're going to interplead the funds. Interpleading the funds creates fewer funds available to fight over, because we have to get paid for the filing fee, and we have to get reimbursed for I think we charge 2 hours of time, or $750 as our fee to process the file and put it into the courts. So there's less money to fight over as it goes to the court. But once that happens, and once the fight is only about the deposit, then you could sell the property to a third party. Again, if the buyer is making a claim for specific performance, not just for their money back, if they're saying, well, we want to close, but the seller says they're not leaving their house, and the buyer's suing for specific performance, and that's why the money's still in escrow, then clearly the seller can't sell it to anybody else, nor do they want to. But if it's the buyer trying to cancel and they've already said, we just want our deposit back, and they're not asking for specific performance, then the seller can sell it to a third party.
Got it. Who can I call for help with a tenant eviction? Do you do that, Paul? And if so, tell them your number.
So we don't like to do them. Landlords are horribly disappointed every time there's a tenant eviction, because the tenants can get to say 2 or 3 things, and the judges who oversee those in county court are in general very favorable to the tenants. They never let them out when they're supposed to get out, etc. Jim Werder in my office is a litigator, and he does handle the evictions. I say we do that begrudgingly because so many times the landlords are angry with the results. His direct dial number is 561-515-4704.
Great. How do you suggest we handle new leases about to start or renewals that are upcoming? Should we add an addendum to protect the landlord if the tenant loses his or her job? If so, what would you recommend it saying?
Yeah, I think you should add a COVID-19 clause that says that we're currently in a pandemic and that you've agreed to move forward and not use COVID-19 as an excuse to not pay rent or otherwise, otherwise fulfill your obligations as a tenant. I would put something like that in a lease just so that, it's already existing in the world. Everybody knows what it is. And if you're moving forward today with all the knowledge that comes with this, you can't then use that as an excuse.
Makes sense. My buyer canceled Friday, 3 days before closing, and gave up his escrow. The selling agent received 50% of it. I did not know that our office was supposed to receive a portion of that. We already signed a release and a cancellation and escrow disbursement. Is it too late to get that portion that our brokerage was entitled to?
It may be too late, but you should certainly try. The applicable lines in the contract are 330, 331, and 332.
Great. Buyers wanted to cancel, and they were post contingencies or past contingencies. So sellers wanted to keep the escrow money deposit. Buyers went out and put a lien on the seller's house. Is there anything that we can do to protect a seller from this?
Yeah, that's a great scenario for the seller. Number one, they didn't have a right to cancel. They only had a right to use the force majeure provision to extend. And so they played their hand out way too early. And the fact that they recorded a lien on the house is a slander of title in which they should be sued for. Yeah.
Nice. I have an upcoming listing with tenants where they are cooperating and are agreeing to show the condo. How do I protect myself from the liability of them contacting the virus and putting the blame on us as either real estate agents or brokerage?
I think to draft some language and put it into the lease.
Okay. On a call yesterday, an agent had stated that they are adding verbiage to all listings and showing instructions that no liability will come back for any person that contacts or contracts the virus while looking at any of their properties. Do you think this is a good idea? If so, any idea on specific verbiage?
I think it's going to be impossible for people to say that they got it from your listing. But can you get sued? Of course, anybody can sue anybody for a nickel in Florida and in the United States as a whole. Horribly disappointing, but true. Yeah, you can add the language in there that just as you've seen on other listings that that listing agent and seller accept no liability, that anybody showing the property pursuant to this hereby holds the seller and the listing agent harmless from any liability for COVID-19 related illnesses.
Got it. Is an email an acceptable means of notifying a tenant of intent to retain a security deposit for damage upon lease termination, or does it have to be sent with certified mail? If the landlord did not notify, this separate one, do that first.
So I'll cover both of those at the same time. An email is insufficient. Florida statutes say that you must send a certified letter to the last known address of the tenant. If you don't do so within 30 days of the termination of the lease, and it needs to be postmarked within 30 days, if you don't do that, you lose your right to retain the deposit. I've had landlords who've made that mistake and then get sued by the tenant, and they have to pay the full deposit back to the tenant, plus the attorney's fees for the tenant's attorney. Now the landlord can then still sue for damages. They just don't get to retain the security deposit as part of that suit.
Got it. If landlord did not notify the tenant of a bank account where the security deposit was held at the start of the lease, but the tenant paid rent, direct deposit, or a cash deposit each month to the LLC, is that assumed that the tenant knew where the security deposit is being held?
Well, the security deposit can be held differently in a different bank account than where the rent's being delivered. So that doesn't necessarily govern. It's interesting in the statute itself, it doesn't create a damage associated with not fully disclosing where the account is. So, I've researched that issue in the past, and unless it's changed in the last few years, and I doubt it, there is no specific damage that a tenant can get for failure to disclose.
Got it. As agents, we are not allowed to write addendums for leases. Question, is there a COVID-19 addendum for leases, or can we use the same one for the sales?
I don't know if FAR has put up with a COVID-19 lease addendum. I know that Nancy Jennings was the one who sent me the first version I saw of the COVID-19 contract addendum. So I think you guys have access to the FAR forms to check more than I do.
With condo associations, is there any way that you suggest dealing with a very unreasonable condo association or one that fails to communicate during these times?
Is there a reasonable condo association? Yeah, I'm having horrible problems right now as well. People just not in the office to be able to handle paperwork. I'm getting questions about, can we close based on a facsimile of the approval? Do we need the original approval? I believe we're authorized at Trident anyway, and Performance anyway, to close on a copy of that certificate of approval given the circumstances.
Okay.
The condo rider specifically says that you have to apply within 5 days, and that the closing is contingent upon being approved by the condominium association. So that in and of itself can be a delay of a closing if you can't get approvals from the condos.
Got it. I know the landlord must notify the tenant that the lease will not be renewed by certified mail within 30 days of the lease expiration, but what if the tenant does not ever pick up the certified letter? So essentially they don't receive it, or there's no proof that they received it.
I'm confused about that because the standard lease does not extend unless notice is given by the tenant to extend. So if the tenant has the right to extend, they have to give notice. Usually you want it 120 days in advance of the end of the lease. The statute, if there's nothing in the lease itself, the statute says that the lease ends at the end of the lease, and it then becomes a month-to-month lease. And after that lease period, the landlord has to give 15 days notice. So by the 15th of the month except if it's February, and to the tenant to vacate by the end of the month. So it's not 30 days.
Got it. One more, last one here, I think. I have a client who's about to purchase a home. The current owner has an 8-year-long tenant in place. The house is in Florida. However, the current owner used a North Carolina lease. Out of curiosity, do the leases need to be state specific? And in regard to her new purchaser, her new buyer, how does the property convey with or without the tenant? What are their options?
So you need to look at the contract. If paragraph 6B is checked, which says that there's a tenant in place and you're taking subject to the tenant, then you're taking subject to the tenant. If that box is checked, then the landlord owes you 2 things. Number 1, a copy of the lease, and number 2, a tenant estoppel letter. If you don't get those on a timely basis, you have a right to cancel until, I think it's 5 days or 3 days after your receipt of those documents. If 6B is not checked, then the tenant needs to be out by closing. And the other question you asked in there was about, can you use a North Carolina lease?
Yeah.
You can use any lease you want. You use it at your peril. It probably is inconsistent with Florida law, and you probably want to use a Florida form if you can.
Got it. If email is not acceptable, this was a follow-up question. If email is not acceptable, what happens if the tenants do not provide a forwarding address to the landlord and there is damage? This was about the security deposit. How can the landlord send a certified letter if they don't have new address?
So I tell I tell the landlords to use the last address of record that must have had an address that they gave them when they applied for the rental. If they don't have that, then I tell them to go to the US Postal Service and look them up online, and you're allowed to use that address, even if it's an old one. But the key is to get it out within 30 days. And there is a statutory form of the letter that you can use that cannot be objected to by the tenant.
Great. Fantastic. Well, I want to thank Paul on behalf of Performance Title and Escrow and Trident Title for coming on and doing this. Remember, guys, on the call, we have Melissa Kidwell, we have Gabrielle Bryce, we have Dave Ward, we have Tracy Sender, we have myself representing all of our different branches and all of our different offices. So if you need anything, please reach out. Remember that you get access to Paul when you're using us. And Paul, just give us one final plug for how they can get to you, or if they need you for your services, how they can hire you, and then we will sign off.
Sure. I mean, we do buyer reps for people. So if you're spending most of your day today answering questions from buyers, it's always, I'm happy to take your call and have a conversation with you on the phone, but it may be preferable for you to say, you know what, you really need to hire an attorney and have conversations with them about that. We're available to do that. We're also available. I'm getting a lot of people calling me about, listen, I can foresee, you know, my need to file bankruptcy, my need to miss mortgage payments. Can you consult with me on that? We do a free consultation in person or on the phone. We prefer on the phone these days. But please remind your agents to say that they're coming from KW. It's a $1,500 value if somebody were coming off the street and asking our opinion. We give it away to you guys for free. Make sure they know that. Make sure they know you're giving them something that's worth $1,500 because of their relationship with you, and let us know that they're coming through you, so we can come back to you after the meeting and let you know what was said and what the results. So
awesome. Thank you so much for that. Thank you for that $1,500 too, guys. If you didn't know that, think about that and make sure you know that. If you need anything, get in touch with myself, Gab, Melissa, Dave, or Tracy. Thank you guys so much. Make sure you tune in on Monday. We're going to have another big Trident training event on Monday. So stay tuned, check your emails, check Facebook, and everybody, thank you so much, Paul, for your time. I know it's valuable, and we appreciate you.
Sure.
Thanks, guys.
Thank you.